If we look at the further flow of the case, I mean, remember we were in Article 3.2, and this throws us back to national law. But the respondent, which was Her Majesty the Queen, or the Canadian Revenue Tax Authorities, maintains that there is no meaning of the term beneficial ownership and beneficiaire effectif for the purpose of the Act, which can be invoked for the purpose of Article 3.2 of the treaty. First of all, according to the respondent, the words used in the Act have multiple and often irreconcilable meanings, and it's true. They give them some examples showing that beneficial owner in the Income Tax Act is used in many different ways. It then also said the Respondents' Council, citing an article by Mr. Bart Brender, submit that there is no settled definition of beneficial ownership even under common law. And then they looked at a British case, the Indofood case, and Indofood was purely about beneficial ownership, but I will keep it very short here because it's not relevant here because the facts are different, right? The legal, commercial, and practical structure behind the loan notes is inconsistent with the concept of issuer or interposed. Newco could enjoy any such privilege, okay? And then it said with regard to the facts, in accordance with the legal structure. So you had Indofood in Malaysia, I believe, which issued notes through a conduit company, which then issued notes to the public, and that treaty got rescinded. I think it was with Mauritius, and then they wanted to see if they could use Holland as instead of Mauritius, but the banks said that this wouldn't work because the BV would not be the beneficial owner. And the reason why they said this comes clear in the highlighted paragraph here. It says, in accordance with the legal structure, the parent guarantor, in other words in Malaysia, is obliged to pay the interest 2 business days before the due date to the credit of an account nominated for the purposes by the issuer. This would have been the Dutch company then. And then the issuer is obliged to pay the interest due to the note holders 1 business day before the due date. So in all cases in Indofood, the intermediate company would have held the interest for 1 day and would have had the obligation to pay on all that interest immediately. So that was part of the court's decision for determining that Indofood was not the beneficial owner, and that was simply not the case in Prevost. So we will leave Indofood aside. And then the conclusion of the parties were the parties agreed that the Prevost Holding BV was not an agent, trustee, or nominee for Volvo or Henleys. Rather, it is the CRA, Canadian Revenue Authority's view that Prevost Holding BV was acting as a mere conduit or funnel in favor of Volvo and Henleys. And this is what the court had to decide. Were they a mere conduit or were they the beneficial owners? And the judge comes with a surprising twist in his judgment. I'm not saying he's wrong. I just didn't see that one coming at the time. He said, in my view, the beneficial owner of dividends is the person who receives the dividends for his own use and enjoyment. Totally agree. The person who is beneficial owner of the dividend is the person who enjoys and assumes all the attribution of ownership. Totally agree. This person is not accountable to anyone for how he or she deals with the dividend income. When the Supreme Court in George stated, that was a Canadian case where they talked about beneficial owner, that the beneficial owner is one who can ultimately exercise the right of ownership in the property, I, that's the judge, am confident that the court did not mean, in using the word ultimately, to strip away the corporate veil so that the shareholders of a corporation are the beneficial owners of its assets, including income earned by the corporation. And this is ultimately where the holding BV or Prevost wins the case, because the judge says, in this particular case, what you're trying to do is you're trying to pierce the corporate veil of the BV and I'm not going to allow this. The money belongs to the BV. The BV is not just a nominee or an agent, and the BV is a legal person, and that's where the dividend belongs. And we will see how the judge words this. He says, when corporate entities are concerned, one does not pierce the corporate veil unless the corporation is a conduit for another person and has absolutely no discretion, very much like Indofood, as to the use or application of funds put through it as a conduit, or has agreed to act on someone else's behalf. This is not the relationship PHBV has with its shareholders. And then he mentions, there is no evidence that PHBV was a conduit for Volvo and Henleys. It is true that PHBV had no physical office, which doesn't help, or employees, which doesn't help. However, for Henley and Volvo to obtain dividends, the directors of PHBV had to declare interim dividends, and subsequently shareholders had to approve the dividend. There is no predetermined or automatic flow of funds to Volvo and Henleys, even though Henley's representatives were trying to expedite the process. It still required a decision by the holding BV to declare and pay a dividend, whether it was a final dividend or an interim dividend. And then it says PHBV was not a party to the shareholders agreement. Neither Henleys nor Volvo could take action against PHBV for failure to follow the dividend policy described in the shareholders agreement, right? So there was this issue that the shareholders agreed they would pay out 80% of the profits of the BV as dividend every year, right? And to the extent that the CRA said, well, look, I mean, PHBV had to pay 80% of the dividends, the judge said, no, wait a minute. That is an agreement between the shareholders. It is not an agreement that involves PHBV in the sense that it's not a party to the agreement. They may want PHBV to follow the wishes of the shareholder, but in no case does paying a dividend because the shareholder wishes that you pay a dividend make that company a mere conduit of its own dividends, right? That it received. And PHBV, the judge goes on to say, PHBV was the registered owner of the Prevost shares. It paid for the shares. It owned the shares for itself. When dividends are received by PHBV in respect of the shares it owned, the dividends are the property of PHBV. The money represented by the dividend continue to be the property of and is solely owned by PHBV. The dividends are an asset of PHBV and are available to its creditors, if any. That was also a bit of the argument in the Indofood case, that if Indofood were the company, the Dutch BV would have been bankrupted between the first and the second day when it received the interest and before it paid it. I mean, that money would have belonged to the creditors. However, the Court of Appeal turned over that argument, saying, you know what, this is one day. Come on, this is not real, right? But in Prevost, if we look at the last highlighted paragraph here, the judge argues any amount paid by PHBV to Henleys and Volvo before a dividend was properly declared and paid, as I see it, was a loan from PHBV to its shareholders. This too is not uncommon, and then he goes on to talk about Canadian tax practices where this is allowed. So even though there was a shareholders agreement, they didn't bind Prevost, and even though Prevost did pay out dividends sometimes very quickly to help Henley, these might have been interim dividends or whatever, or it might even have been before the dividend declaration, the judge says that's fine. Those were just loans in that case. And his judgment comes to the point and he says, the assessment will be vacated. Volvo and Henley were not beneficial owners of the dividends paid by Prevost. I have not heard any evidence satisfying me that PHBV was a conduit for Volvo and Henley's, thus the appeal is allowed. Now, what is interesting about this case, I really like it because it really deals with beneficial ownership in quite a proper way. There's been subsequent cases. I mean, there's been Indofood before. There's been the Danish beneficial ownership under EU law, but I feel the issue there was EU law as such, so I don't quite see them as the same level as PHBV. But there is, of course, BEPS, and the question is, if this judgment were to be ruled after BEPS, whether the judgment would have been the same, whether PHBV would still be the beneficial owner. And I think the answer is yes, it would still be the beneficial owner. The question would be whether it would be entitled to the treaty benefits, right? And if you look at the new paragraph 12.5 on the commentary to Article 10 on dividends, the commentary says very clearly, the fact that the recipient of a dividend is considered to be the beneficial owner of that dividend does not mean, however, that the limitation of tax provided by paragraph 2 must automatically be granted. This limitation of tax should not be granted in cases of abuse of this provision. The provisions of Article 29, so the limitation on benefits and principal purpose test, and the principles put forward in the section improper use of the convention in the commentary to Article 1 will apply to prevent abuses, including treaty shopping situations where the recipient is the beneficial owner of the dividends. So had Prevost been decided today, maybe they would have lost under Article 29, but I am not sure, because I think it remains a fair argument for companies when they go into joint ventures to say they want to do it through a separate legal person. I think it also remains a fair argument for companies to say they don't want to do it in the other country, in the other joint venture partners' country, if they are from different countries. So they might want to do it in a third country, and one would assume that this would entitle them to the treaty, to the benefits of the treaty, especially if they would have had the same benefits otherwise. If either there was no treaty with one of the joint venture partners and the investment object of the joint venture, or there was a much higher withholding tax, maybe you have more of an issue. But I don't think it's a foregone conclusion that you would lose in a fact pattern like you had in Prevost. That is what I have for you this week, and if you have any comments or suggestions, let me know. If you have any requests for other cases to discuss, let me know, and otherwise I look forward to talking with you next week.